morning, Rob.
Hey, everybody, it's Rob Seaver, Executive Director with PACE. I'm here with one of my favorite people of all time, Michelle Schuster. She is partner over at MacMurray Shuster. And Michelle, I can't thank you enough for joining me this morning to talk about this very important thing. As you can see behind me, I've got my red stranger danger light on. Something's going on in the space. Listen, let's get right into it. Last Thursday, short term, at least, my world changed quite a bit because I started getting blown up by this thing, which may not have been the intent of Thursday, but I will tell you that people started calling me right and left. Obviously, as I was reading your blog, which, by the way, if you don't subscribe to MacMurray Shuster's blog, you can go out there and get the last right up to the minute information right into your inbox. So it's a little plug for you, Michelle. But help us understand what happened Thursday and why are all of our members asking what's going on?
Yeah, I mean, the FCC threw down the gauntlet. They said that they have identified loopholes was one of the words that they used. They had identified areas where they believed that consumers' expectations weren't being met about what and when and how many calls they'll get. And so they have proposed several rules and then also announced further rulemaking that they intend to engage in. And based on what was released, we anticipate this stuff to happen quickly. So this is something we really need to get out to PACE members to make sure that they're prepared for what we see are likely changes in the lead generation and telemarketing space.
So I read a little bit of it. I've read what you've written and a couple of other articles. And what I can tell you is that there were two areas that I want to really address very quickly. The first one concerning more the text messaging, the report and order, and what that meant. Because quite honestly, for a long time, I've been thinking that texts are calls, right? Calls are text, texts are calls, and the courts have kind of sided with that opinion in the past, right?
Yeah. So the FCC early on interpreted the requirements for getting consent for calls that are made using an automatic telephone dialing system to also apply to texts. So that's what we have the FCC on record saying. For purposes of ATDS, automatic dialing prohibitions, a call is, or a text is a call. However, what they went on to say in this further notice of proposed rulemaking regarding text messages is that they did not specify that text messages are calls for purposes of the do not call laws, meaning they didn't specify that you have to scrub telephone numbers before sending texts. Now, we do have courts out there. The Soderfeld versus Simon & Schuster is the most notorious out of California that said that text is a call and therefore you have to meet all of the TCPA requirements. And so I think the marketplace out there, the callers and the lead generators have been following that for the most part. What's kind of earth-shaking about this is if the FTC hasn't declared that a text is a phone call and the FCC has authority under federal law to interpret the TCPA, then all of those cases that have been brought in the past that have filed lawsuits against companies that sent texts and didn't scrub against the do not call list, what happens to those? If they've already been rendered on a final judgment, probably nothing, but I guess there is possibility there. But if you have a case pending that alleges that you made text messages in violation of the do not call laws, then I'm sure your attorneys are doing much research now and thinking about motions that can be filed, and they should be.
So, I mean, to me, this sounds like just furthering that definition and the explanation about how these regulators are viewing text as almost synonymously with a voice call, right? So this just goes a little bit further down the pipe of what it's expecting and scrubbing against the DNC. Do you see that this is going to be a heavy lift for the people in the space, or do you feel like most people are already doing it, or what are your words of wisdom on this area before we move on to the NPRM?
I think most companies have been doing this. I definitely think the more mature, established companies have been doing this at their advice of counsel because of the real threat of a class action lawsuit against them. So, I never want to say it isn't a heavy lift, but this is one that will be easier than the others.
So let's talk about the others. And this is what I think most of the people are up in arms about, or at least very concerned about the direction that this might go and how it relates to impacting their business. The notice of proposed rulemaking. As I was reading this, obviously there were several areas that caught my eye, in particular, talking about the marketing partners list. And in general, it's not the first time in just a few months that we've heard about the partner list. You actually were on the stage at our ACX in Nashville in October talking with Lois Greisman from the Federal Trade Commission about this very thing. And so is this more in the same of what you were talking about with Lois, or is this different, or help just break it down for us?
It's the same, but
it's
different.
As easy as
it's
that,
the
right?
same, same but different is probably
different.
about as clear as we can make it. But just the important thing here is, and Rob Pace has been talking about this for quite a while now, starting with the formation of the anti-robocall task force and what their aims were, and the lead generation forums that purported to get consent for thousands or even hundreds or even dozen marketing partners in linked marketing partner lists is something they have said they despise for quite some time now. Lois Greisman said it very clearly on the stage at ACX last year. And she, of course, was interpreting the telemarketing sales rule, which is what the FTC does, versus the Telephone Consumer Protection Act. But it shares the same sentiment that we're seeing across the field of all regulators, AGs, FCC, FTC, local prosecutors that have jurisdiction over these types of things. And so, when I say the gauntlet has been thrown down, it has been. They are now taking steps to formalize this. And in the case of the FTC, it's revising the TCPA to provide a different definition for prior express written consent than we currently have.
Yeah, I mean, look, I've been through your sessions before when we talked about consent, prior express consent, prior express written consent, and as clear as that stuff has always been to me, how is this going to impact that? I did read a little bit about, and it's, depending on how you read it, I think, and that always is a subjective, find, but depending on how you read it, it looks as if well, the way I read it was like, okay, I can only share one marketing partner. Is that what I'm talking about? Or is there something different here? And I am familiar with the terms, condition, the link out and the marketing partner list, but help me break that down a little bit. What are they talking about here? Are we limiting? Is it just one, or what have you read about it?
So the interpretation that I think is reasonable is it can be more than one. And if you look at the definition that the FCC is proposing, and we'll talk about, what it's going to take to get this implemented before we end this session, but basically what they're saying, and I'll give you the definition as it would be revised.
Please.
And this is put at the end of the definition that currently exists for prior express written consent. And it says, if the prior express written consent is to multiple entities, so conceiving that it could be, the entire list of entities to which the consumer is giving consent must be clearly and conspicuously displayed to the consumer at the time consent is requested. To be clearly and conspicuously displayed, the list must at a minimum be displayed on the same page where the consumer gives consent. So I think that the definition being proposed by the FCC would allow for multiple marketing agencies, multiple sellers to contact them, and they would have consent to do that. The thing that will be most important as people are interpreting and implementing this rule is they're really going to have to look at whether it's clear and conspicuous. And the FCC has given some guidance on that and said that it must be topically and logically related to the website on which that consent form appears. And so, you and I have had conversations about that. I think there are several areas, especially with our PACE members and Consumer Consent Counsel, that are doing this type of lead generation related to mortgages and insurance and home improvement and things like that. And so, I think that they will be working with their counsel to craft these types of forums to make sure that they are logically and topically related and that is clear and conspicuous to the consumer that these companies would be calling them or texting them.
So help me, let me give you a scenario here. If I primarily offer some sort of rate shop for mortgages or insurance, right? And a consumer comes and they say, hey, look, I really would like to see 4 rates, right? Before I decide who to pick. Are you saying that like if it is a 5th insurance company, that might be appropriate, but if it is a 5th company that sells walk-in bathtubs, that would not be an appropriate marketing partner to list on that same page? Is that what you're saying? And
I'm not saying that.
maybe you're not saying that.
I'm not
Okay.
saying that yet.
You're not saying that yet.
We're
Okay.
going to have a lot of comments that are submitted on this, including Pace. Pace will be submitting comments on this, and we will be talking about those very things. And that's the purpose of this comment period, is to make sure that the FCC understands from industry, from our members, what the effect of this rule could be and any unintended consequences, and then offering solutions for those unintended consequences. So I'm really urging Pace members to get involved in this comment process. Isaac Schloss, who is the head of our Government Affairs Committee, will be convening a group. We will be working with experts in the field to craft comments that represent this industry and provide the FCC with a clear indication of what the rule's unintended consequences could be, and then propose ways to get around that. So these are the very things we're going to be talking about, Rob. I mean, the FCC said, and if you look, and I really do encourage everybody to go read this, it will take a while and bring some coffee, but you will notice that there are more footnotes than actual substance in the document. And so there are a lot of references to what they have received in the past by way of input, and they give some hints as to where they're likely to go. So
this isn't our first rodeo. I mean, I remember reading this, back in 2015, we formed a coalition with other associations to basically help the FCC define the definition of ATDS. Is that correct?
It goes back even further than that.
Oh, wow.
One of the first things we did as general counsel for PACE was to get involved with a request for declaratory ruling on the definition of ATDS, because we saw where that was going. Several other associations did as well. And that's what ultimately resulted in that 2015 declaratory ruling that basically said any type of phone that wasn't a rotary dial phone was an ATDS. And as soon as that was published in the Federal Register, we filed a request for reconsideration to the DC Circuit Court for that. And that led a long battle around the definition of ATDS that ultimately culminated in the Facebook versus Duguid decision, on which the Supreme Court relied to a large extent on the amicus brief that we had submitted. So this is something we have a lot of experience with. We maintain relationships with the regulators so that we can come in and have conversations with them when we file comments like this, and that is our intention. And we are really looking forward to members getting involved in this process.
Can you help me real quickly, just from a timeline, because I know that just for everyone that's viewing this, LeadsCon is coming up in March, I think 13th through 15th. And we have the largest lead generators in the space that will be meeting around our board of directors table to discuss this and help propose and craft some of that response that the industry is going to have. And so if you have any comments and you'd like to participate, please email myself, rob@paceassociation.org, or Michelle. Certainly, I'm sure you would welcome anyone contacting you also if they have questions or want to get involved. Is that correct?
Absolutely. mschuster@mslawgroup.com.
mschuster@mslawgroup.com. I think I email that more than once a day. I've got that memorized.
I think we do, Rob.
So how fast is this going to go? Because I talked to you a little bit about this before the call, but in general, what are we talking about timeline here so that the people out there can get an understanding of what they could be expecting?
So the open meeting notice that had these attachments included with it is for March 16th. So on March 16th, the Federal Communications Commission will vote on whether to release this notice of proposed rulemaking. It will happen. After that happens, they're required to file it with the Federal Register. And when it's filed with the Federal Register is when the clock starts to tick and gives 30 days for interested parties to file comments. After that 30 days, another 30 days is granted for reply comments. And we would anticipate participating in both rounds of those. However, we will start preparing and already are starting to prepare, as Rob said, at Leeds Con. We'll be having a meeting there to start to respond and to give real world examples of how we can still improve the lead generation space, because I think that there is no doubt that there will be a change, but to the greatest extent possible, so that we are the ones that have input into that. And, you know, I would say, Rob, we've been working on the PACE SRO, and the definition of clear and conspicuous for lead generation is something that we have incorporated in that. And so, you know, as we work to finalize those and get those where they really need to be, especially in light of this, this is something that companies will be able to turn to, so that they'll.
You're going to make clear and conspicuous, clear and conspicuous.
Mm-hmm.
Is that what you're talking about?
Yes, for purposes of lead generation, we are. I feel like we already have, we just haven't released it yet, but it's very much in line with what the FCC is proposing, maybe not as specific about on same page and those types of things, but that's something that obviously we can incorporate as well if that ultimately does become a rule.
Michelle, what I do know, I've been doing this for nearly 8 years now. And, you know, some of the lead generators that are in this space are absolutely, you know, lifelong friends of mine. I've really come to know most of the people in the space and just really appreciate the people who are here. What I do know about this space is that people do want to do right by the consumer. I'm confident of that. I've talked to enough people and they have that forward. You know, there's been a prediction that this is the death, you know, the nail in the coffin for lead generators. You know, what I'm hearing from you, there's a level of optimism that, yes, this isn't ideal. This isn't the way that any industry or any company would want to move forward with making change in their business. But having said that, I can't think of an industry that's more adept at making change to accommodate the regulations and the laws and protecting consumers at the same time. And so this does not feel or seem to me like the death of. Is that what we're talking about here, or are you in the same camp that I'm thinking?
So I have experience with this from a long time ago, starting with the passage of the do not call laws and the ATA, which morphed into PACE, came to the Attorneys General's offices, and I had the privilege of being the consumer protection chief under Betty Montgomery, who was the chair of the NAG, National Association of Attorneys General Consumer Protection Committee. So we were at the center of these do not call law developments, and PACE went in and told the AGs that if the do not call law was passed, that the industry would die, that it would cease to exist, and that would affect consumers who would leave choice and the convenience of being able to make purchases over the telephone and get more information over the telephone. And we see that the industry has been adaptable. They have conformed to that. They have thrived still. And what I did see after that, when I came over to the industry side, was what these rulemakings help, what these strengthenings of laws help, if we're going to try to find any bright side to it for industry, is that the people that do it right rise to the top, stand out, and they find a way to make the business model work. And that's what we as an association have to help our members do.
Yeah, I couldn't say that any better than you did. That's why I asked you to say it. Look, Michelle, I wanted to get this out quickly. I wanted it to be the first of many pieces of communication that we have on this. Obviously, you've already written about this. I know that you'll write again about this. You're already engaged with the FCC and the other regulators on an ongoing basis. So this isn't the first day that you've knocked on their door. What I can say is that you said something about we could, and you probably expect this to be at least out and finalized before the end of the year. Are you pretty solid on that at this point?
I mean, it's anybody's guess, but yeah, I mean, the environment feels like the regulators are moving quick and that their constituents are demanding that. So, you know, if I was a betting person, I might put a small wager on the fact that this could become that this could modify the TCPA by the end of the year.
Well, according to every commercial that's on my TV, it's legal to bet in almost every state now. So maybe we can go ahead and do that. I don't know. Tired of those commercials, by the way. Michelle,
Yeah,
I can't thank you enough. What was that? What were you going to say?
I was going to say, I don't know that the odds would be that great in our favor.
Well, look, I really appreciate this time. I know you're busy and just wanted to get something out. We'll have more to come. Look forward to meeting you guys in Las Vegas and discussing this with you in person. Can't wait. And once again, thank you for being members of PACE or considering PACE. And we're out there working for you every day. Thank you very much.
Thanks, Rob.